Hi, I'm Anna Denton-Jones of Refreshing Law, and I'd like to encourage you to review your drugs and alcohol policy or any section of a sickness absence management policy that refers to dealing with drugs and alcohol issues. And the main reason that I suggest that you review these policies is actually quite frightening statistic that I read the other day that under the Global Drugs Survey, 20% of employees reported that they had consumed drugs within 2 hours of then attending the workplace, which is obviously quite a frightening statistic. These days, there are lots of substances that people are abusing that wouldn't necessarily be covered by, if you like, our good old-fashioned drugs and alcohol policies that probably refer to things like the 1971 drugs legislation. So, for example, if somebody is abusing prescription drugs or painkillers, those sorts of things, steroids that may well be legally available but can still be impairing their ability to function, then your policy may not actually cover what you could be dealing with. The second area, of course, that has had lots of press attention in relation to our criminal law trying to keep up with the development of these things is the so-called legal highs, substances that are obviously often marketed as bath salts or some kind of animal product that people are using to then get themselves a high. Again, we need to make sure that our policies would cover those sorts of things. If you haven't got a drugs and alcohol policy, then it can be a lot more difficult when you want to try and take some kind of action against an employee where there is an issue. Or indeed to support that person if they do come forward and admit they've got a difficulty and that they need help. It's useful to have that structure and framework of a policy around it. The other thing that I get asked about a lot is about testing policies and the extent to which employers may or may not test for drugs and alcohol consumption. Here in the UK, I would say the most common form of testing is where there's been some kind of incident. So it's a reactive form of testing. And employers will have procedures in place where, for example, if somebody has crashed the forklift truck, that a test can be done at that point to establish whether drugs or alcohol have contributed to that accident. Another form of testing, which I've certainly seen some employers decide to implement, where they became concerned about the level of usage of substances within their workforce, is at recruitment stage. It is possible to have a test as part of the recruitment process. And certainly if you speak to occupational health professionals and those involved in the testing industry, they will say that if an employer is well known for testing recruits, not only will it prevent the employer perhaps from recruiting people where there could be an issue, but it also sends out the message to the wider community, perhaps that you don't want to go and work in a particular employer because they do test if you are a drug user. The third area of testing is much less common here, unless you work in very specific industries, would be random testing. And it is possible for employers to include a clause in the contract of employment that at any point they may choose to randomly test their staff. Some employers will do that from the perspective of it just even having that in there being a deterrent and that having a value. Obviously, there are certain procedures that need to be put in place around that to make sure that the testing is done in a rigorous way and protecting the rights of everybody concerned. But it is possible to use it if you need to. If anyone's got any questions, please do give me a call. My email is adenton@refreshinglawlimited.co.uk. Thank you very much.